Hello, everyone. My name is Ronnie James. I'm here with Great Plains Action Society. Tonight, we're going to be talking about the current state of reproductive rights and bodily autonomy since the reversal of Roe v. Wade. And we have a special guest tonight, Sally Frank. Sally's a professor of law at Drake University and a legendary attorney with a very storied background. And I'd like to bring Sally on.
Thank you, Ron. I'm glad to be here, and I've known Ron for many years and worked with him, and it's a pleasure to work with you again. So, what I want to talk about tonight, or the way I want to present this, is as you well know, the U.S. has a long history of abusing women and people of color in every area of the law. Reproductive justice is just one such area. Tonight, I plan to review how these issues were dealt with, the reproductive justice issues were dealt with in the U.S. Supreme Court, and then I hope we'll have plenty of time for questions. A lot of very detailed legal concepts I'm going to be bringing up, and so please in the Q&A ask me to explain more, some of them more to you, but this could take hours, and so I'm limiting the way I'm framing it, but would happy to expand on any parts you would like. And really looking at the history, the legal history of issues really begin with the issues of sterilization. And the first U.S. Supreme Court decision on sterilization is a truly horrendous, horrifying case called Buck versus Bell from 1927. There, the state of Virginia had a law that they passed in 1924 that said if people were mentally handicapped and had been through multiple generations of mental handicap, then the state could apply to have the person forcibly sterilized. These were generally done in homes for the handicapped. Ms. Buck was living in a home in a place for people with mental disabilities and epilepsy. And the court just sort of went through all of the due process, meaning all the hearings this person could get and the appeals they could take, and said, no problem. And from this, we get a very terrible quote from Oliver Wendell Holmes, who normally is thought of as a great jurist, where he writes, 3 generations of imbeciles is enough. And that was actually quoted back during the Nuremberg trials of the judges and lawyers for the Nazis having really taken this kind of line and this premise and run with it and said, well, your Supreme Court did this, so why are you blaming us? So that was sterilization. What's scary is that opinion has never been specifically overturned. The next big sterilization case, instead of overturning Buck v. Bell, they just narrowed it and said how that doesn't apply in this circumstance. And that case was Skinner versus Oklahoma in 1942. And I wonder if the fact that World War II was going on and how much the Nazi crimes had reached the Americas for them to realize that they needed to do something different. I'm not sure if that was an effort or not. But Oklahoma in 1935 passed a law that somebody who had been convicted of 3 felonies and certain kinds of felonies would be sterilized. And the only defense in a hearing was that if the sterilization would cause other physical problems for the person. That was the only defense they could have. And the person who was at Mr. Skinner, his first felony was having stolen chickens. The court went in an equal protection analysis saying certain kinds of theft weren't subject to this law and certain kinds of theft were, and therefore there's an equal protection problem. But the court mentions at the side that there is a substantial liberty interest or that there was an invasion of personal liberty in sterilization. And so that's the beginning of notions of liberty under the 14th Amendment. And the 14th Amendment is important here because the 5th Amendment applied to the United States, the 14th Amendment applies to the states. And you look at the Bill of Rights being incorporated into the 14th Amendment. But the court did it on equal protection grounds that, somebody who did one kind of theft wasn't subject to this, but did another kind of theft and they were. But there were concurrences that really looked at these issues of what liberty means. And of course, when I reread Buck and Skinner, my first thought was, wonder what the races of those people are, or the economic level. Somebody who stole chickens, obviously we don't think much, that's at least poverty, if not race and poverty going on. And that when you look at who was and wasn't subject to it, you can get that the racial issues and the poverty issues. We're going to kind of fast forward, but I think, let me just, before I fast forward on the Supreme Court, of course, since 1942, there have been over and over again scandals about forced sterilizations. There's one in the Carolinas, I think in the 80s or 90s, where a doctor, if a woman was on welfare, would make the woman agree to be sterilized when she gave birth. That on the agreement to take care of her in birth, he'd have her say, yes, I can be sterilized. As recently as 2 years ago, of course, in ICE custody, some women were forcibly sterilized through an ICE jail. So that, issues of forced sterilization are always with us, and you can't talk about bodily autonomy or reproductive rights if you don't talk about the right to have children if you want them. And so sterilization is an important piece of this. But if we move forward to starting the development of liberty interest law that eventually gets us to Roe. So looking at it, it's looking at substantive due process is the legal term, but what they're really looking at is what does it mean to have a liberty interest? The 14th Amendment says you can't deprive someone of life, property, or liberty without due process of law. So what is liberty that is important here? And early cases involved a parent's right to send a child to parochial school or to religious school if they want. There is freedom of association, the right to join with other people to try to affect social change. There is the right to marriage, the fundamental that the court said was a fundamental right. And all of these they found in the sense of what is liberty. What does liberty mean? It's not only freedom from jail, but liberty has a broader meaning than that. And before we get to contraception, the other big one with right to marriage is then Loving versus Virginia in the early 1960s. That said, most states, or large numbers of states, not most, but many still banned in the early 1960s interracial marriage. And Loving versus Virginia, the court said, no, you can't ban interracial marriage. When we get to the Dodd opinion and you see all of what Clarence Thomas wants to undo, somehow Loving versus Virginia is not one of the ones, even though it stands on the exact same properties as all the others. Funny thing that could have anything to do with the fact that he's a black man married to a white woman. Oh, who would think it would be personal for him? So those all kind of came along. And then we have Griswold. And Griswold is a case about where it was illegal to talk about or to prescribe contraception to married couples. In Connecticut, it was kind of a purposeful test case where Planned Parenthood had a meeting with married couples where they described it, told the police ahead they were going to do it to set up a test case. And in Griswold, the court specifically talks about a right to privacy. And that the right to privacy, they find it in several places. They find it in the Ninth Amendment. And the Ninth Amendment says, I thought I had this open to the Ninth Amendment. Okay, anyway, the Ninth Amendment says that just because we're listing some rights doesn't mean that we're listing all rights, and that there are other rights that people retain even if they're not on the list. And it was written in the Bill of Rights because people were worried, if we do a Bill of Rights, are we going to miss some things? That's dangerous. But if we don't have a Bill of Rights, then people don't have rights. And so this debate went on. So the Ninth Amendment is like, it's not everything. So there was the Ninth Amendment. And the court also talks about weird word called penumbras, the kinds of things that just obviously come out of things of the Bill of Rights, like freedom of association. How could you, there in the First Amendment, there's a right to petition the government for redress of grievances, there's a right to peaceably assemble. Well, if you can't have freedom of association, who are you assembling with? So you can't really have the right to assembly if you don't have freedom of association. So it just kind of comes right out from it. And so they found a right to privacy within the penumbras. If you think of a sun, the rays of light that come out from the sun, that's penumbras of the First Amendment, the Third Amendment, the Fourth, and the Fifth, as well as the Ninth. So the Fourth Amendment is the right to be free from unreasonable search and seizure. That's the warrant requirements. The Fifth Amendment is the right to remain silent, and therefore you can keep your thoughts to yourself. The Third Amendment is the one most people forget about. It's probably the most successful amendment we have in the Constitution because it's not an issue anymore. And that is that the government can't require you to house soldiers. It's the quartering of soldiers. So if the National Guard comes through and says, hey, we need some extra housing, Sally, why don't you house a couple soldiers? I can say, nope, no, thank you. It really doesn't come up much. So that's why I think it's the most successful. But within all of those, they found a right to privacy and the thought that the police could go into a married couple's home and try to search to see are they using contraceptives or not, or watch them to be in the act and see if they're using any kind of contraceptive was really horrendous to the court. And so a majority found a right to privacy and a right to contraceptive use. The question is, how do you determine what's in the Ninth Amendment, the rights left to the people, and where rights that are not specifically stated come from? And some of the language they looked at is that you look at the traditions and collective conscience of our people to determine whether a principle is so rooted there as to be ranked fundamental. Also, whether a right is of such character that it cannot be denied without violating those fundamental principles of liberty and justice, which lie at the base of all our civil and political institutions. Kind of mushy test, but you kind of look at history, you look at what's always been thought of as fundamental. That's important to keep in mind when we get to Dodd and what the court did with that. Griswold soon got expanded to first unmarried adults and then to teens. A common strategy of lawyers is you bite off a small amount with each chunk. You don't want to take a big bite. So if the first case were teenagers wanting contraceptives, it might not have worked out as well as married couples. So they built it slowly. After those three came Roe v. Wade, and that was the abortion decision. And that set up the trimester system, that abortion was a fundamental right of a woman in the first 2 trimesters of pregnancy. That in the first trimester, the only regulations the state could set up were about basic health and safety. In the second trimester, the state has more interest and can do a little more regulating, but again, in the area of the woman's health and safety. Only in the third trimester did the court say that the potential child or the fetus had competing rights, and that you could then, the state could put the pressure, put the recognition on the rights of that fetus, and could deny abortion except to save the life or health of the woman. And Roe is very interested in the connection with doctors and the woman and her doctor deciding. Justice Blackmun, who wrote it, had worked for a hospital system before he got on the courts. So that probably was his perspective and frame of mind. Roe was a compromise. At that time, there were many in the abortion rights movement who wanted to say it wasn't a human being until birth. And actually, I'm Jewish, and that's the Jewish view, is it's not a human being until the head is out of the woman, out of the body, and then they've got 2 people. So Roe kind of drew a compromise between the two, looked at a lot of history about where abortion regulations come from and what people felt about abortion along its way. And it was really a very thoughtful decision in that regard. And that was January 1973. And but after that came, there started to be fallbacks on it. Um, the first major problem was the Hyde Amendment, named for Congressman Henry Hyde, that banned federal funding for abortion, including Medicaid, unless it was definitely for the life of the woman, maybe the health, and then depending on who had power in Congress, uh, there might or might not be an exception for rape and incest. This is a problem today. It has affected you all because the National Health Service, including the health providers on the reservation, if paid by the federal government, can't do abortions except to save the life or health of the woman and maybe rape and incest based on the Hyde Amendment. So it doesn't only limit Medicaid, it limits it can affect women in the military and access to reproductive health care in the military. Uh, some of the ideas of how to get around some of these things by like setting up abortion clinics on federal land is problematic if the federal government spends money on it. So Hyde Amendment has been very far reaching. In some states, people have gotten, the state Supreme Courts have said no, state must use its own Medicaid money because abortion is a fundamental right and we're not going to exclude low income people from it. But it has had an impact for a long time. In the first maybe 10 years of Roe, almost all the state regulations that tried to limit abortion got eliminated, got thrown out, because abortion was a fundamental right. And to limit a fundamental right, the language is you have to have a compelling state interest, and the law must be narrowly tailored to meet that compelling state interest. So that's a kind of odd legal test, but it means that most regulations weren't going to survive. That started changing in the late 80s. In 1989, the Supreme Court upheld a Missouri statute that said that the fetus was a living human being from the moment of conception as a state policy, but it did not outlaw abortion, but it did prevent any state funds from being used for abortion. So that, and there had been presidents then railing against it and trying to appoint justices to the Supreme Court who they thought would overturn abortion. 1992 is the Casey decision. And the Casey decision, in many ways, I've always thought of it as having overturned Roe, but they said they didn't. They said that they were keeping the fundamental principles of Roe. They got rid of the trimesters, and instead they made a date of when the fetus could live outside the womb on its own. And at that point, the state could ban abortion. And nowadays, that's around 24, 25 weeks, depending on how close you are to a NICU, neonatal ICU, and things like that. But it also said that the state could regulate abortion unless the regulation created what they called an undue burden. And when you look at there were 5 regulations before the court, and the only one they threw out was husband notification. They allowed a 24-hour waiting period. They allowed consent, informed consent, what they called informed consent. And we all know that you need informed consent for any medical procedure, but in abortion, it wasn't the doctor who was telling you what the risks of the procedure were. The state was writing it, forcing the doctor or the medical staff to tell the woman. And not all of those supposed outcomes and problems were true. It's just a state script. So informed consent, waiting period, parental notification, or for minors with a judicial bypass, reporting requirements, and the spousal husband notification. The only thing they threw out was the husband notification. After that, states were going to town, passing every which way, all kinds of regulations that they were hoping would not be found to be undue burdens. And the only ones that really started to be found an undue burden by the U.S. Supreme Court were ones that said you had to have the doctor who was doing an abortion had to have admitting privileges at a nearby hospital, but the hospitals wouldn't, of course, give them admitting privileges, and that they had to be like a full surgical place with the same level of space and this and that isn't required for abortion. So that was a situation. Casey came out during a presidential election in 1992. And I've always been moved by Justice Blackmun's semi-concurrent, semi-dissent, where he talked about that, we thought the light of freedom was going to go out, but it's still there, but it's only a thin flickering flame. One vote makes the difference. And then he put in, which I thought was surprising for justice, I am 83 years old. I cannot stay on this court forever. The person who replaces me may well decide whether that flickering flame goes out. We lasted another 30 years, but that was the precursor. That was the warning. And I know I read it at a pro-Clinton rally to point out to people what was at stake in that presidential election. Well, and as we all know, Trump got three appointments to the court. One of them he certainly shouldn't have had. Mitch McConnell had his way with it and got, basically stole an appointment from Obama and then rushed through an appointment at the end. I often think Thurgood Marshall and Ruth Bader Ginsburg are just commiserating with each other about how horrible their replacements are. But as Trump was president, as the justices were being appointed, states started to try to actually really go at Roe. So you've got 6-week, the so-called fetal heartbeat legislation, which is essentially banning an abortion after 6 weeks. Not that there's really a fetal heartbeat, but that's what they're calling it. You've got this 15-week ban that Mississippi had. And you had many states passing laws that said if Roe is overturned, if Casey's overturned, immediately we're banning abortion. So that was kind of what was around when Dodd got to the Supreme Court. Dodd versus Mississippi, or Mississippi versus, anyway, Dodd and Mississippi. And Mississippi had a law that said no abortions after 15 weeks. And the U.S. Supreme Court took that opportunity to overturn Roe. Essentially, 5 justices wanted to overturn Roe and Casey and uphold the law. Justice Roberts, the Chief Justice, wanted to uphold the law, but not say they were overturning Roe versus Wade or Casey, or the Casey decision, which was just kind of covering up what they were really doing. And 3 justices dissented. But what's worse than them throwing out Roe and Casey is the way they did it. They said that the only way you determine if a right is current, if something was a real right, one of these fundamental rights that are not stated specifically, is whether or not it was considered a right in 1868 when the 14th Amendment was passed. Now, if that were the test for miscegenation laws, interracial marriage laws, you know that Loving versus Virginia would be overruled. And many of our rights, depending on how you frame the right, would be lost if we looked at what the state of the law was in 1868, especially the case where the Supreme Court overturned laws that made it a crime to engage in consensual sodomy, and the marriage equality decision. Both of those would not stand, depending on how you frame the question. And this is one of the issues to me. Justice Alito said, look, every state banned abortion. It had abortion bans in 1868. So therefore, abortion could not possibly have been viewed as a fundamental right, could not possibly have been viewed as part of the notion of liberty. The question I would ask is not the narrow question of abortion. What I would ask is, in 1868, was there a recognition that white men had a right to bodily autonomy? And if we think there was, and I think there was, then the only reason why people of color and women didn't have that same right is because we weren't granted equality. Far from it for people of color. We were, people of color were just freed from slavery recently in 1868. Native Americans were subject to genocide and forced onto reservations and then forced into Indian schools. You all know this history better than I do. So the notion that women somehow didn't have this right in 1868, so we shouldn't have the right now. Women couldn't have credit cards. Women couldn't sign contracts. Married women couldn't sign contracts in 1868. Our notion of what rights women have is just totally different. And our notion, at least should be, of what rights people of color have should also be totally different with the recognition of full equality. So if white men had the right to bodily autonomy in 1868, then women and people of color also today have the right to bodily autonomy. And that includes for women, white women and women of color, the right to reproductive justice, the right to not be sterilized if we don't want to be, the right to have an abortion if we want one, the right to accessibility to all forms of birth control, accessibility to IVF if we need fertility treatments and we need to use that to have children, and we need proper state funding because abortion, all of these are part of medical care, and women have a right to the full range of medical care. So the court purposely is asking a wrong question. It absolutely was dismissive towards Justice Blackmun's history in Roe, was dismissive to the notion that um, equality requires women to have control over their own reproduction. They're just totally dismissive of these. And what we're left with is state by state laws, and women are going to die. We're already seeing that in states that ban abortion, doctors are afraid to help women who have had miscarriages because the treatment for a miscarriage is the same as what you do for an abortion. It's to make sure nothing is left in the woman, because if anything is left in the woman, she could end up developing bacteria and viruses and end up dying. So, but doctors are afraid to give the appropriate medical treatment in the case of a miscarriage. Similarly, further along, if something happens to a fetus during development and needs to come out for the woman's health, some of the states that have an exception for a woman's life is like imminent death. Well, so you have to wait until she's completely septic before you treat her, or where is the line? So it's a complete disregard for women's health and women's lives that are coming from DOD, that are coming from our states. Some states already now abortion is banned. In Iowa, it is still safe and legal. Please know that it's still safe and legal, but there's a 24-hour waiting period. But I personally am hoping people vote more on their rights, an issue of their rights in this election, than necessarily on the economy, because otherwise women die. And on that happy note of women's death, sorry, um, I'm happy to take questions. I know I went through, almost 100 years of Supreme Court case law, and but want to answer and focus where you're at.
Sally, that was great. Thank you very much. One main thing that you pointed out that really gets to the heart of it with regards to um, the question of 1868, and like the only people that had bodily autonomy at the time was white males. So any equality laws add to that, and it should be the same standard from each law moving forward. I think that's really a bulletproof argument. So I had a few questions. So since much of Roe v. Wade was questions of privacy, there's a lot of fear of how does this reversal going to affect privacy immediately, and then possible outcomes outside of just health autonomy. And does that reversal affect like previous data collected by companies or the government?
Well, that kind of privacy, the Constitution doesn't govern what private companies do. So that's going to have to take other statutes to govern what private companies do. Congress shall make no law doing this or that. The only constitutional amendment that is aimed at private parties is the 13th Amendment against slavery. But so it won't have any impact on that. But what's scary is Justice Thomas and his concurrence wrote about how they should take the principles they're writing and overrule Lawrence v. Texas, which was the decision that overturned state laws against consensual sodomy, and the marriage equality decision, and that they should do that right away. Alito was saying, oh, this narrow decision doesn't go to those because abortion is different. But if you read all the reasoning, it goes to the heart of those other issues as well. But as I said, it also goes to, and he also wanted Thomas wanted rethinking of Griswold. So let's take away gay rights. Let's take away the right to contraceptive information, and we can ban that because we want to keep women pregnant. And as I say, the one thing he didn't mention was the Loving versus Virginia, which would have affected him personally if that one were overturned. So we have to be very watchful and careful, because this court is a very radical court. It's not conservative. It's radical right wing.
Yes, absolutely. Are there any other aspects that aren't commonly covered the reversal will affect in U.S. life?
Well, what you have to do is look at state laws. So I think it was Oklahoma. What a good state, huh? Oklahoma was passing a law that said that life began at the moment of fertilization. And that's why I brought up IVF. In IVF, you fertilize more than one egg. And what do you do with that fertilized egg if by Oklahoma law it is a human being and medical practitioners can't eliminate a living human being? Then what happens in IVF, and could that eliminate IVF? Or they usually also implant more than one fertilized egg in a woman to see what will take, and then they sometimes have to remove one because it's going to fail and it's going to affect the other one. That could well be illegal. IUDs work, I believe, by preventing implantation. So if it prevents implantation, are they then going to say it's an abortion method instead of a contraception method? So I think there are several of those kinds of things that could be in trouble. And just the absurdity of what they're doing. There's recently been articles about a woman who got a ticket for being in the HOV, in places with a lot of traffic, they'll often have a lane on highways for carpooling. And so if there's more than one passenger, and she said, but I'm pregnant, so therefore, by definition, there's another passenger. There are two of us in this car. And I think it's true. I had heard it. It could be apocryphal, but when Missouri passed the law that said that life begins at conception, a woman was in jail and she petitioned to be freed, habeas corpus, because her fetus was being unjustly imprisoned and she was pregnant. So, I mean, it shows you the absurdity of saying that something that can only live within someone else is a full human being. It just is, to me, it's ridiculous. It is a potential life, and it certainly has value. And, I would oppose anyone who tried to force someone to have an abortion. But to say that as an equal human being, to me, makes no sense.
Yes, absolutely. Another question I had, and this one, I don't know if it's something you're able to answer, but I've been scratching my head on it. So, who actually benefits from this reversal? To be blunt, in the U.S. in a tangible way, who is going to profit from the reversal?
I think it's part of Christian nationalism, and not all Christians, but this very conservative movement in Christianity and the fundamentalists that want women back in the home and don't want women participating equally in society. Because starting with the pill and contraception, and then abortion let women fully participate equally in our society. And if you can't control your reproduction, you can't be full equal participants. And just a side note, because I just think it's really funny. When I heard it, I loved it. That somebody did a history of the pill, and apparently, when it was first approved by the FDA, it was approved for menstrual problems and not for contraception. But there was this really negative potential problem with taking this medication, which was it could prevent pregnancy. And so it was listed as the part of the commercials for drugs about doing this can cause this, and this. Well, doing this could cause prevention of pregnancy. And of course, doctors noticed that. And a lot of women got prescriptions off label for its, negative instead of its positive.
We have a question from a viewer. Kristen asks, are there any inalienable rights where the precedent has been set where a recognized right is no longer recognized?
I wouldn't view it as an inalienable right, but others did for a while. There was this view in the Supreme Court that you had a right to contract, and therefore we shouldn't set government can't set minimum wage standards because it interfered with individuals to do their own contracts with their employers, knowing, of course, how much power workers have against their employers as individuals to negotiate. But so there were, I think the people who proposed that contract was a fundamental right might have seen that as a backdrop. Most of us see it as a labor rights real improvement, and the Lochner series of cases are very much thrown out. But otherwise, I do not believe there's really been any fundamental inalienable right that the Supreme Court has reversed and said, nope, no longer a right. We've been, to quote what's so often been quoted from Dr. King, the moral justice of the universe arcs towards justice. That's where we've been going, which makes this even worse and more devastating.
Okay, thank you for that. Is there anything else that I guess since me and you are both based in Iowa, what do you predict the Iowa laws will look like?
I'm sort of surprised that the governor hasn't called a special session of the legislature to outlaw abortion. I think they may be worried that it wouldn't be popular. So what the Iowa had, this is why it's a double whammy for people in Iowa. Iowa had a 2018 decision from the Iowa Supreme Court that recognized a fundamental right to abortion in the Iowa Constitution. And a week before the Dodd decision came out, the Iowa Supreme Court overturned that. Two of the justices who had been part of the majority in that decision tragically died before their time. I died relatively younger, not real young, obviously, because they were on the Supreme Court, but died young, one from cancer and one just dropped dead walking his dog. And two others had retired, and it had been a 5-2 decision. The fifth one is retiring this month. I'm not sure which day. He may have already retired. So that was the double whammy, but the court said it's unclear how to review state laws limiting abortion. And this involved a 24-hour waiting period, and whether it was that undue burden test from Casey, because in 2015 they had decided a case using undue burden, or if it's rational basis. The thing to know about a rational basis test is almost anything and everything gets approved if it's rational basis. All the court has to do is come up with a rational reason that a legislature might have done this, what it did. I even did do it, but might have done it for any reason that's rational, and it survives. So they sent it back down to the district court. I expect it'll take a few months before it wends its way back, and eventually the test in Iowa will be rational basis. And once that happens, then the legislature will be free to outlaw abortion. And so it might take several months somewhere in the next legislative session. But I expect they will be outlawing abortion. The issues will be whether they criminalize the woman, whether they criminalize the providers, what the exceptions are. Presumably, there'll be an exception for the woman's life, but what beyond the woman's life? Will they have a rape incest limit exception? The story of the 10-year-old rape victim that had to cross state lines to get an abortion, hopefully hit some people's souls and made them think. But so, the full parameters, I don't know. But basically, I expect if the current power remains where it is and the governor is reelected, not that I'm saying anything partisan, but if the powers of the legislature remain where they are and the governor is reelected, we will have a ban I expect, within about a year. And there are all kinds of issues that are coming up with this besides, the issues with IVF. There are states that are trying to criminalize women leaving the state for an abortion. Now, Kavanaugh, in his concurrence, said, well, that would be unconstitutional because there's a right to travel. Of course, nowhere in the Constitution does it mention a right to travel. This is another one of those basic rights not mentioned. And would people who help her, who are in that state, end up being aiding and abetting an abortion? Would they make it another civil thing like Texas did with SB 8, where, if anyone who aids a woman having an abortion after 8 weeks could be sued? Are we going to have to set up, very quiet channels to help get women from states where it's illegal to states where it's legal along the way so that more poor people can have access? And obviously, women will die. Not only women who have miscarriages or major problem pregnancies will die, but also women. Women have always had abortions, whether it's legal or not. Women are going to get an abortion, and the question is, will they do something that will harm themselves? And could they die from it? Pre-19, talk to any nurse or doctor, that worked emergency rooms or OBGYN or any of those areas before 1973, and they will tell you the heartache and pain that they saw of women dying or being maimed, who tried to self-abort, went to a back alley, not qualified abortionists and things like that. So it's going to be the responsibility, I think, of all of us to help women get to where they can get it safely.
Yeah, absolutely. Could you tell us, just so everyone watching is just clear on where the current law is and how the 24-hour wait works?
Okay. So in Iowa, as I said, abortion is still safe and legal. Don't be intimidated by all of what's gone down. If you want to come to Iowa, or if you're in Iowa, it is still safe and legal. But what there is now is a 24-hour waiting period. I'm not sure exactly how Planned Parenthood or the Emma Goldman Clinic in Iowa City, and I don't know if there are any other clinics not affiliated with Planned Parenthood in other parts of the state, but I'm not sure how they're doing it, whether they're scheduling appointments actually 24 hours apart so that people can come back the next day, or whether they have to come back a week later or what. When is the doctor in? When do they do these? And I'm not sure what the scheduling issues for them are, but it isn't implemented. So essentially, if you want an abortion in Iowa, you have to make an appointment. You come in, you get a sonogram. And if you want to, you can look at it. You don't have to look at it, but I think you have to be offered to look at it. They have to tell you the state script of what they claim is informed consent, whether it's true or not. And then you have to think about it for a day, because of course women don't make these decisions, don't think about the decision before they come to the abortion clinic in the first place. So you have the 24-hour waiting period, and then you have to make another trip, whether it's the next day or how further away, to actually have the abortion. And Iowa has a law that you can't have an abortion after 20 weeks. So, obviously one of the problems, what if you're in your 19th week and you go and you get the lecture and the stuff, but they can't schedule the abortion before the 20th week. So there's still issues there in that regard. And recognizing that it's, if you live in Des Moines, it may not be that hard, or in Iowa City, to go twice to get to the clinic. But if you live in rural Iowa, if you live several hours away, if you're low income, if you're in an abusive relationship, if you don't have vacation days from work, all those kinds of things, it can make to make 2 trips is that much harder than 1. And so, that's one of the ways I'm looking at. Well, do people need to be, if it's one day and then the next day, do people need to be put up overnight? Or what do we need to help women who can't afford a hotel and, for whom it's a long drive? So even where it's safe and legal, we still may have to help people.
Okay, thank you for that. Is there any other obstacles in place for minors?
There is I believe Iowa has parental notification with a judicial bypass. So in other words, if you can't tell your parents and you want to get the abortion anyway, you have to go in front of a judge and explain to the judge that you know what you're doing, you've thought about it, why you can't tell your parents. In Polk County, I think judges are very, open to the judicial bypass, but you can have places where judges are absolutely against such a thing. And so, it really varies where you are. But I don't think there have been big issues in Polk County of getting the judicial bypass where necessary. That's the other big one. And that, besides, of course, price, because, a 15-year-old, a 25 and 30-year-old might not have the money for an abortion. A 15-year-old, that's even harder. And of course, when do they realize and make decisions and things like that? So
Absolutely.
I see a question in the, wouldn't the Interstate Commerce Clause block the attempts by states to regulate travel between states? That's the question. It should, but either by civil suit or by, it would be hard to press the woman. Are they going to be looking at her phone? You're going to want, if you are a woman that's having to cross state lines, you want to make sure you're using something like Signal and other things that won't keep your search history available to subpoenas and things like that. So states that are very pro-choice have been passing legislation to not do full faith and credit, not recognize any subpoena to a doctor doing, or to anyone in, let's say in New York or in California who is helping the woman, as long as under California law they're doing it legally, they're not going to assist, let's say, Alabama in trying to shut them down, and won't recognize an extradition if Alabama tries to prosecute a California doctor for doing it. So, you've got a full breakdown of federalism and of the states, because the blue states are trying to protect the people that come to the blue states, and the red states are trying to impose red state law on people in blue states. So it's really kind of crazy. And part of the harm of what the Supreme Court has wrought.
We've got another question from our homie Jessica with GPUS. She's asking, will the advent of DNA testing have a big impact on the situation? Pre-Roe, people could much more easily skirt paternity.
Well, I think pre-Roe, you'd do paternity tests and you'd only know whether the blood type. And it could be, and he could say, no, it's not mine. And she could say, yes, it's yours. And the judge would decide. The only thing it doesn't really impact abortion. It impacts child support. And now some women might feel less of a need for an abortion if they knew that they would have the funds to take care of the child, and if child support would come through. Of course, that assumes that the man actually has income. Right? If the man's income is almost nothing, then the child support's not going to help much. And I do a lot of divorce cases and custody cases. So, if he doesn't have anything, that's not going to help her in raising the child. The whole $30 a month is just going to go so far to help the child. But so I don't think it's really going to affect abortion particularly, but yes, to actually now to get public assistance for a child, a woman does have to name who she thinks the father is. Then they go after the father, and the father can demand DNA testing. At least in Iowa, the state will pay in those circumstances for the father's DNA testing. But I don't, as I say, I don't know that that makes a huge impact on whether a woman wants to carry a child to term or whether she and the issue of coerced birth. And I think that's a way to talk about this issue, that if you eliminate abortion, you are doing forced birth, coercing women to give birth to children.
Yes, absolutely. I suppose maybe with some of the incest restrictions or regulations, that the DNA testing could help there.
Well, yeah, but then that puts him in prison. It doesn't help raise the child.
Mm-hmm.
And when you're talking about a younger child, just the physical toll of, no 10-year-old should be bearing a child. That's going to cause so much just physical damage to a 10-year-old.
Mm-hmm.
Abortion can cause physical damage to a full adult. It's going to cause a young teen, it's just going to cause tremendously more damage just as the body works for the pregnancy. And it's worth noting that risk of harm, you're more likely to die giving birth than having a first trimester abortion. Now, that doesn't mean, of course, everybody should have an abortion, not risk giving birth. People want children, those who want children. But if you're talking purely in terms of medical risk, and the dissent in the Dobbs case also pointed out how much worse maternal mortality figures were in Mississippi and child mortality figures in Mississippi, and how Mississippi healthcare was so bad. And this is the state that's trying to coerce birth.
Yeah.
And of course, outcome by race is even worse, because doctors don't believe women of color as much when they have complications and don't take their knowledge of their own bodies as seriously and as well. So that's, added to it.
We have another question from Kristen. Given that forced pregnancy is listed as a crime against humanity, is there any recourse via the international law to protect bodily autonomy?
Not in the United States. The U.S. somewhat recognizes international law, but I think Justice Souter tended to cite it more than anybody else, and the conservative justices absolutely, got angry every time he would cite international law. And we don't have a mechanism. Europe has the Court of Human Rights that can actually overturn a nation's government's law or judicial opinion. The United States doesn't. The U.S. Supreme Court is its top body. So it's more using this argument, talking about this in terms of hopefully convincing minds, talking to people, but it's not going to get us anywhere with the courts. The OAS doesn't have enforcement authority. The World Court, the U.S. hasn't joined. Well, the World Court is more about treaties, is about land disputes between countries and things like that. We're the big bully who says you always have to follow legal order unless we're the ones that aren't following it.
Yeah. As we've seen at the United Nations International Declaration on the Rights of Indigenous Peoples, I believe the U.S. and Australia is the only nations that haven't signed onto that and don't recognize any of it. And,
all the treaties signed with tribes, with native tribes in the United States, and the enforcement on that has not been exactly what it should be, to put it absolutely mildly.
Yeah, not a stellar history there. I think that's about all I have. I don't see any more questions from the audience. Is there anything else you'd like to close with?
Well, I just think we all have to commit ourselves. I know you've got a lot of things on your plate, but I think this is one of those issues that we're going to have to commit ourselves to organize on, to recognize, to support other people, support each other. I'm not of an age where I need that particular support at this time. I'm beyond it, but many people do. And so we're going to need to support people who need to be able to have reproductive rights and safely exercised. And we need to vote. This is now in the power of the states and the state legislatures and the state and the governors. And, for a long time, the other side made it a litmus test for their vote. And we have to start making it a litmus test for our votes. And I just want to thank you all for being part of this and listening to it. And if you have other questions or other ways I can be of assistance, please feel free to contact me.
And how would they contact you?
My email is sally.frank. So you see my name's up there. So just sally.frank at Drake, DRAKE.edu.
Excellent. Thank you so much, Sally. We couldn't have had a better guest for this. Full disclosure, Sally kept my butt out of jail a couple years ago, so I'll forever be grateful. And as she continues to help us, I'm just blown away by your generosity with this. So thank you very much. I also would like to thank some of the supporting orgs. This was made possible with help from Iowa Jane Collective, Iowa Abortion Access Fund, Iowa Coalition for Collective Change, Des Moines Black Liberation Movement, and Des Moines Mutual Aid.
Well, thank you all for being here, and thank you, Ronnie. Always glad to help and work with you.
Thank you, Sally. You're the greatest. Have a good night.
You too. Bye.